he was around the truck on the sidewalk and in the road.
So the father will be there.
I mean, we sent a lot of text messages, so.
But you didn't bring those here today, did you?
I mean, I've got him printed out and on my phone. But I've never kept him from him.
Custody battle alert. Child support turned into a custody flip for 4-year-old Ashton. Mom says she missed the January hearing notice, and now Dad's got most time while contempt hangs over transport and visits. Stick around for the receipts, the rulings, and the courtroom heat right now, today. Subscribe, like, and share.
Your Honor, this is a case that started as a child support action and then was converted into a custody action. There's a 4-year-old child between the parties at this point. The child has lived the majority of his life up until these proceedings with the mother. Father had limited contact for quite some time, but upon seeking child support, he sought time with his child. Ms. Hewitt represented herself for quite some time in these proceedings, and importantly, there were orders that came down regarding visitation and what that looked like and what that would be. Importantly, the court considered and granted some unsupervised visitation right before Christmas, where the father would have, I believe it was on weekends, from 8 a.m. to 6 p.m. on Saturdays to come see the child at the mother's home. Subsequently, there was a motion filed on January the 21st of this year that was set for hearing on the 29th, a week and a day later, that effectively asked for the court to flip this custodial schedule at that point, citing some issues and some things that the father had concerns regarding. At that time, notice was mailed to my client, but she never physically received that notice. She had been here for every single other hearing that had occurred except for the one where she did not get the notice in time. And with not having the notice and without being here, the court entered the order where the father had the majority of the time with this child and put some onerous terms on the mother, including making her responsible for transportation and some other costs that father knew that she could not afford. Mother currently does not have reliable transportation, and the criminal contempt that we're seeing is related to that and some of the transportation issues that came from this order where mother was not noticed and did not know to participate. At this time, the child has not had much time at all with the mother since that order came down. I believe there were maybe 2 or 3 visits since January that the mother has had because of this transportation issue. The father lives over 2 hours away in Kentucky with this and has taken this child and has in no way facilitated any of that contact. Instead, when mother asks and tries to communicate that she has difficulty transporting and moving this child, he shows up with the police and files this criminal contempt. We will say that this child is at substantial risk of harm, that he has been completely severed from his connection with his mother, that he was raised primarily by his mother up until January of this year when this court changed course, and that he is not having the stability in the placement that he needs, that he's been removed from the home that he's known, the family that he's known, including his sisters and other siblings, that he has not been getting the therapy and the other resources that he was getting through the Dixon County school system in Kentucky, and that we are seriously concerned about where this is going and what is happening to this child with this change in custody. And again, we're just seeking to go back to the status quo and then reassess and see what we need to do moving forward, because we're not denying and saying that he can never have time with this child. We're just saying that this change is too much and too fast for this child that does have some developmental delays and does have some other issues. Ultimately, father set mother up for failure unilaterally at that hearing on January the 29th, and now, in addition to the motion for criminal contempt, they filed a motion for a parenting plan, where if you read their proposed parenting plan, it gives father 365 days with this child and mother 0. They are trying to control the situation and take this child away from the mother. And I am not disputing that it was mailed or not mailed. We don't know. But what we can say is that mother never received this notice. She was not participating in that hearing. And ultimately, we're seeking this child to be able to return to mother because there have been no substantive issues that have brought about this change in custody.
Deal first with the motion to reconsider this case for some of the history. This case initiated, as was pointed out, by a petition to establish paternity and for support. That complaint to establish was filed in September of 2024. An order went down in November of 2024 to establish paternity and to establish a child support obligation. And from that point, and in fact, I think I'm the one who signed the order of confirmation of that. Then following that, there was a petition to establish visitation that Mr. Fenton had filed, and that came before the court, and we ended up having a hearing, and there was order of visitation that went down. During the hearings, both in that and the parenting time of Christmas of 2024, Ms. Hewitt appeared pro se and testified about the extensive medical conditions that this child suffered from and how this child had heart issues and other major health issues that she was addressing, and that was her opposition to having overnight visitation with Mr. Fenton. That I found that at the December 18th, 2024 hearing, the mother testified that she had objected to unsupervised visitation due to the minor child's various medical conditions and treatments. However, the proof overwhelmingly at that hearing in January established the fact that the mother was either untruthful or ill-informed, both of which are unacceptable for a primary parent. The mother also testified that she had been managing and fulfilling the minor child's medical care and developmental needs. However, the proof was overwhelming that the mother had failed to meet the child's needs. Court finds that the mother delayed the child's access to services from Tennessee Early Intervention Services for about a year. Furthermore, the child missed 2 consecutive months of developmental therapy by April 12, 2022, due to the mother's failure to cooperate with the therapist. The mother also delayed the child's access to physical therapy and failed to have the child evaluated by a speech therapist and ophthalmologist as prescribed in the child's PCP, which is primary care provider Carol Moore. I found that the child requires evaluations and follow-ups for autism, speech, ophthalmology, as well as a well baby checkup and a 2-year follow-up with a cardiologist. I found that the mother had neglected the medical and developmental needs of the minor child, and that the overwhelming evidence demonstrated that the mother was not capable of providing the care the child required. The father had actively sought to arrange for the child to receive necessary medical evaluations and treatments, and he has demonstrated both the willingness and ability to meet the child's needs. He testified that the minor child did not experience any issues in his care during his residential time. And I went on to find that I considered the factors in Tennessee Code Annotated 366106, and I found it was in the best interest of the minor child to designate the father, Matthew Christopher Fenton, as the temporary residential primary parent. And I went forward then to set a residential schedule for the mother. That is the order that I entered. That is the order that, in my opinion, should be upheld, and I am at least, I'm not going to grant the motion to reconsider because, in my opinion, proper notice was given, and there was a factual basis for the rulings that I made at that time. I will then overrule the motion to reconsider and move on to the motions for contempt.
I'd actually take him with me.
Okay. So the first 90 days, you were to have supervised visitation at Miss Hewitt's home. Is that what you stated?
Yes.
And and what time from what time was that?
From 12 to 9.
12 to 9. So you had a hearing August 30 of 2024. So when was your first supposed visitation?
The following day, it would have been August 31st.
August 31st of 2024, is that
Yes,
correct?
yes, ma'am, correct.
Okay. And let me go back. During the hearing of August 30, 2024, Ms. Hewitt, was she present at that hearing?
Yes.
All the way to when the judge made his ruling on your specific visitation?
Yes, that's correct.
Okay. All right. And then so the first day that you visited, August 31, 2024, were you able to see your son that day?
Yes, for a short period of time, about an hour and 20 minutes. And Miss Hewitt had told me to leave, that I would not be coming around there every other weekend. And so I left.
Okay. And so your time was cut short. So if you had from 12 to 9 p.m., so that would be 8 hours, correct?
Yeah, well, no, 9.
9 hours?
Oh.
I'm not good with math. I think it's 8 hours.
Okay.
And so then so did you say that you only visited about an hour and a half that day?
Yes, it was
Okay.
about an hour and 20 minutes or an hour and a half.
Okay.
And I was asked to leave.
Did you perceive any reason why you shouldn't be allowed to complete your 8 hours of visitation?
No, she just got very rude and told me exactly that I needed to leave, that I would not be coming around there every other weekend,
Okay. And so that happened August 31st.
or every weekend, I'm sorry.
Okay. All right. So then let me take you to September the 28th, 2024. Tell me what happened on that day.
See, August
What was
31st.
the date again? I'm sorry.
Was that,
September 28th, 2024. Did you send her, did you let her know that you were going to arrive?
yeah, I let
To
her
her
know I was
home?
going to arrive, and she had messaged me and said that it was her stepmother Connie's birthday, and that she was be going to her father's for that, and wanted me to reschedule my visitation for the following weekend. And I messaged her back and I let her know that, I'd been waiting all week to see Ashton, and I did not want to miss my visitation. And she brought up child support, and had I sent it yet? And I just let her know that I was be on the way. And she messaged me back and said that she would call her father if I sent the child support and see if he could come later in the day to get him, and postpone the party till later that evening. And I told her that would be okay. And then she messaged me again about child support, and I didn't respond. I just let her know that I was heading that direction. And right before I got there, she had sent me a message that she had left, or maybe when I got there, I can't really, it's been so long ago. I might have pulled up. I think it was 12:04. I pulled up and I messaged and said, "I'm here. Are you at your house?" And she messaged back and said that she had already went to her father's house, and they would not be back until later that day. I think it was 8 o'clock, and that I couldn't have visitation.
And so on that day, September the 28th, 2024, was that a Saturday?
I believe so.
So that was an appointed day for you to have your visitation, is that right?
Yes, ma'am.
And you did not have the visitation? Is
That's
that
correct.
Participants in that text messaging?
Me and Ms. Hewitt.
Okay. And you did say October 26th is the date on that text messaging?
Yes, it says Saturday, October 26th at 12:14.
Okay. Is that another day where, is it your appointed day to
Yes, that's
exercise
correct.
your residential time? Okay. And so read that text message for us.
She said, I text her and I said, "I'm at your house for visitation with Ashton. Are you at home?" She said, "No, we're at Daddy's for his birthday this time." And then I replied, "Today is visitation, so are you coming back?" She replied, "Well, you change up Saturday and Sunday whenever you want." And I text you about his birthday and got no response. That was completely false. She had never texted
Just
me.
go ahead and read.
And then I've replied, "You must have texted the wrong number. I've alternated every other week like the judge ordered." And then it said, I replied to this. I said, "We went to court on 8/30/2024. Visitation started the next day, which was Saturday." Then she replied, "Connie's cooking and got him a big cake."
Is that the end of it?
Well, no, it keeps going. I just got to flip the page. It didn't show it all. But had replied, Connie's cooking and got him a big cake for Paw and giving gifts. And she said, I'm sorry, but I text you and you weren't at Daddy's for his birthday. That text you that we were at Daddy's for birthday. And then I said, I replied, that's no excuse, it's contempt of court. She replied, no, it's not. We had a prior engagement and I text you. And then she replied again, we have had lives over 3 years without you and still do. Stuff comes up, that's life. And then I replied, I'll file contempt of court on Monday and see what the judge thinks about it. And she said, okay. And then she sent me a thumbs up.
Okay. So Judge, I will play.
At 12 o'clock sharp, Dad shows up for court-ordered supervised time, and it turns into a doorstep showdown. He's recording, asking for Ashton, and Mom's daughter answers while Mom comes out furious, snatches the child from his arms, and the visit ends instantly. That's not co-parenting. That's conflict on camera for everyone.
Is it an audio recording?
A video recording.
Video.
So do you recognize that?
Yes, ma'am.
And where is that taken?
That is at Amy's house, right?
And
directly.
who was taking that?
I was, because I pulled up and I got
I'm just asking who took that.
I took the
Okay,
video.
don't explain. And then so, what time of the day did you take that? Was it at the beginning of your visitation?
Yeah.
At the beginning of your
Right at 12
visitation.
o'clock, as soon as I pulled up, yes.
Okay, right at 12 o'clock.
Who y'all say that runs her mouth about my goddamn daughter and shit? No. Give me my baby now.
I'm here for my visitation, Amy.
Yeah, not here. Grab your brother. Grab your brother.
He's all right.
No, he's not. Give me my son.
All right. So I need to just leave then? Is that what you're telling
If
me?
you don't want it to have visitation like you're
I'm
supposed to,
visitation in your house, right in front of it.
that's not my fucking house.
This is your house right here.
That's not your truck.
My truck is
The
in front of your
parking lot
house.
Is not my house.
All right, we'll take that.
Explain what was happening in that situation there.
I pulled up, I knocked on the door for visitation at 12 o'clock. Miss Hewitt was in the back room. When you walk in her house, you go to the living room and then there's a hallway, and she was in the very back room in her bedroom. I'm assuming because she had walked out that way. But her daughter had answered the door, Sophie, Ashton's sister, and it was a nice day, we always went outside to play in the yard, or I would take him to the park that's just walking distance down the road. I had been teaching him to climb those stairs because he has physical developmental delays, is what they called it at that time, but he was just kind of learning to walk at 3 years old. His feet turned in really bad. He didn't have a lot of muscle strength, so every time I would teach him to climb those stairs, there's 10 all the way to the top, we'd count as we go up, and then he really enjoyed getting in my truck, and he would play with the buttons, and he liked the horn, and so that was a normal routine. When I got him, he'd be waiting at the door, grabbing his shoes, ready for me to put him on and take him outside. And Miss Hewitt had just come out of the back room, and by the time I made it to the top of the steps, made it to the truck door, and opened it, she came out irate, and she had said a few things before, and I just grabbed my phone and started recording at that time.
Is it true that you exercised your visitation in your truck?
I mean, it was never a problem for him to go, but no, I did not exercise the visitation in my truck. Typically, it was in her house, especially if it was a rainy day or if it was sunshine, we would go outside to play. There's not a whole lot of area to play there, but about 500 feet down the road, there is a little park area. And most of the time, it would be me and Sophie would take him down to the park.
Okay.
Or Asia might have been there at that time as well. My fiance. And
And who was she directing to grab her child?
that was Sophia that was up there, ran past. I was holding Ashton in my arms.
And then who grabbed or who took Ashton from your arms?
Miss Hewitt came up
Okay.
and took him out of my arms.
Okay. And so after that encounter, were you able to have visitation that day?
No.
So you just left?
Yes, ma'am.
I just have a few questions about some of these incidents that you mentioned and some of the things that happened. You mentioned this alleged incident that happened on August 31st where you showed up, you saw your child for a short time, and then Miss Hewitt told you to leave. Is that right?
Yes.
But you don't have any proof of that beyond your testimony here today, do you?
No, sir.
And you were allowed to see this child, and you did see that child on that day.
For an hour and 20 minutes. That's correct.
And on September the 28th, we see the messages in the back and forth. She had messaged you previously to try to reschedule that, and you just didn't reply to her. Isn't that correct?
No, that's not correct. I did reply.
Okay. But she had discussed rescheduling that date with you, and you just weren't having any.
I had to leave out of town the next day, so I could not reschedule for my job.
But that visit, you were later able to make that up and have that time with your son.
No, sir.
Your testimony here today is that you never were able to make up the September 28th visit. She never offered you other time outside of what you were court ordered to let you make up that time.
Yes, she wanted me to come the following weekend, but like you stated earlier, it's 2 to 2.5 hours from my house, so you're talking a 5-hour round trip. I work.
So she offered you an alternative and you said no.
Yeah.
And as a matter of fact, on that September 28th, after that party, you were able to see your son for a little bit that day.
No, that's not correct.
Not correct, okay.
She did not show back. She told me she wasn't coming back until like 8 o'clock at night, and that's not possible. I have to get up for work.
On October 26th, sorry, before I stop or move on, you don't have any other proof, you don't have any other videos or anything else, any recordings of this time on the 28th, do you? You don't have them here today.
No, I don't have them submitted as evidence. That's correct.
Let's move on to October 26th. Again, there were messages between the two of you, and she attempted to reschedule that, and you didn't text her back.
She never texted me, period. It states that in the messages that I never received any message from Miss Hewitt.
So your testimony is that you never received any message at all regarding trying to reschedule or trying to have just a different date on the calendar?
I never received anything from Miss Hewitt on that date trying to reschedule. That's correct.
And you were also able to make up that visit and have time with the child later after that, weren't you?
No, that's not correct.
Let's move to this visit that occurred on November the 3rd. We saw the video. You were still under supervision at that time with your son, weren't you?
Yes.
Okay. And your testimony was that you took this child out of the home to your truck
Yeah, we climbed the stairs up.
without telling the mom.
Miss Hewitt never really engaged. She was always in her bedroom, in her bed, every visit.
So on this November the 3rd visit, you take this child that's supposed to be supervised during this visitation out of her home and you place him in your car, and that's when this altercation occurred.
No, we walked up the steps. I walked to my truck to grab a water or something out. He was not placed in the car. She walked out as soon as I made it to the truck. Sophie, his sister, was directly beside us.
Is she an adequate person to supervise these visits?
She was the only one that was there for most of the visits. Like I said, Miss Hewitt was always in her bed in the back bedroom.
And after that that exchange where she was saying, give me my child back, you voluntarily left, didn't you?
Yeah, she was showing animosity and hostile. That's not good for my child to see that, I don't think. I think it was best to defuse the situation at that point.
She didn't deny you any time. You voluntarily left. Is that a yes or a no?
Yes.
Okay.
But when she asked me if I need to leave, or I asked her if she needed to leave, she told me yes. So it's her home.
You never provided any text messages for that September the 28th when your lawyer asked you and you testified that you had offered for him to stay and things of that nature. Do you have any text messages to show that?
To show what?
You testified that you sent him some text messages.
Thank you. I mean, we sent a lot of text messages, so.
But you didn't bring those here today, did you?
I mean, I've got him printed out and on my phone. But I've never kept him from him.
Now watch the cross-exam trap. Mom admits she told him about her dad's birthday on the same day he was supposed to visit. No week ahead warning, no real planning. When she starts rambling, the objection flies, the judge overrules, and the question gets repeated. The record is painting willful in bold.
On that October the 26th, and that was incident with regards to,
My dad's birthday.
okay, that was your dad's birthday. Isn't it true that you texted him that you were going to your dad's birthday celebration on that day?
I let him know that it was his birthday and if we could reschedule, but he didn't want to, and so
Judge, this is non-responsive, I would object. I'm just asking,
I came
did
back
you
and he
send
saw
that
him.
message
Hold on,
that
we have an
day?
objection. She's objecting, non-responsive is not an objection to her own question. Non-responsive is saying that her answer is not responsive to the question. Overruled.
So, Ms. Hewitt, let me rephrase.
Restate your
I'm-
question.
Restate the question. All I'm asking is, on October the 26th, which you are saying it was your father's birthday, isn't it true that you sent the text message about the celebration on that day, that same day?
Yeah, I let him know it's my dad's birthday.
Okay. So you did not give him prior notice, not the day before, not the week before. It was on that day when you told him, hey, by the way, you can't visit with Ashton because I'm going to my dad's birthday, correct?
I don't know if it was the day before or not, but bottom line is he saw his child that day.
Okay. And that's your testimony that he did see your,
Yes.
okay. All right. Let's talk about the video recording that we played. Is it your testimony that Mr. Fenton is teaching Ashton to go up the road by himself?
I'm not saying he's intentionally, that was his motive, but that's what was happening. Because he was sitting out in the truck in the road. And so every day he started running up the steps and just trying to go straight out in the road after, because most of his visits, he would be basically in his truck.
Okay, when he would do that, would Matthew be there engaging with him? He would run up to the stairs to see his father, is that right?
He was around the truck on the sidewalk and in the road.
So the father will be there when they're outside.
I mean, his girlfriend was in the truck and he would be around walking, doing things. And that's why I was watching out. I was paying attention, cars going by. And that's why I got so irate. I'm like, it needs to be in the house or in the yard, not in the road.
And how long has this been going on before November the 3rd?
I mean, it was going off. I mentioned it probably the last few visits, but
Okay. This COVID situation, you testified that you told him for that November 9 visit, and you may have been confused here. November 9 visit, you testified that you told him Ashton had COVID, but isn't it true that the COVID positive test was November the 21st, correct? Because I have your text message here too.
okay.
You
but-
agree with that?
I mean, I agree, he
Okay.
got COVID then, but he also tested positive for COVID before that.
So the November the 9th, the COVID was not the reason. The reason was that you told Matthew that there was an
He was gagging on
ophthalmology
his-
appointment. Let me finish my question. November the 9th, he had his visit, and then it was cut short because you said there was a 2:30 ophthalmology appointment, correct?
Yeah, and he was
Okay.
fine with that.
Okay. Your lawyer asked you about November the 9th, and your answer was, I told him that Ashton had COVID. So that was not true.
Well, I mixed up the dates. It's in
Okay.
the text messages.
Fair enough. Okay. But there was a COVID positive test. It was just not November the 9th. Can we agree on that? It was November the 21st, correct?
I guess.
Okay.
The court has considered the testimony regarding the initial motion for contempt in count, well, I'll deal with each one of the counts. In count one, there's a testimony that his parenting time was supposed to begin at 12, and he was supposed to, under that original court order, was to be given, I think it was 12 to noon, or to, I think it was 1 to 9 maybe,
12 to 9 p.m.
12 to 9. And so that's a period of 9 hours that he was supposed to have visitation with the child. That couple of hours or 4 to 5 hours is not the same as 9 hours, but in any event, it appears that that was during an adjustment period when they were beginning to try to set up the visitation and begin the visitation. And most of those instances, this court is of the opinion that those explanations that were given don't rise to the level of willful contempt because of the fact that there was some visitation, it may have been cut short, or he may have agreed to not. The cutting short of the supervised visitation on the date when we had the child up on the sidewalk, and she came out, her response is indicative of her attitude towards the visitation entirely. And that is also reflected in what I'll deal with in the next set of motion for contempt. But as to the initial motion for contempt, I do not find that proof rises to the level of willful and deliberate contempt, criminal contempt, and therefore I find her not guilty of those charges. On the second motion for contempt, there's really only 2 instances, and in those instances, she was supposed to be complying with the order of this court regarding the change of visitation and the schedule of conduct. It's interesting that the fact that she was able to obtain transport to pick the child up, but suddenly then transport fell through. Frankly, this court does not find Ms. Hewitt to be a credible witness based upon not only today's testimony, but also my observation of her demeanor in today's testimony, my observation of her at prior hearings in this court, and my belief that there was misrepresentation at the very least to this court at prior hearings regarding the medical condition of this child, which has been later proven by satisfactory to the court's satisfaction by evidence at a prior hearing when I changed the custody of the child. So when I read these text messages, for example, on the count 1, which is the February 7th date, when she picked the child up and then wasn't going to return the child, and he indicated he'd be there to pick him up later this evening, and then she said she'd be there later to pick him, be up there later this evening. He'd be ready at 6, and then on the 9th, when he was supposed to be ready to go home to his dad's, her statement was that her car couldn't make it. Connie just let me know she couldn't take us and so forth. And then she said, I don't have any way to get there. He said, I'll come and get him. I'm on my way. Because he had a cardiologist appointment. Again, that's one of those factors that the court used in determining that this child was better off with the father than with the mother, was that the child's medical needs were not being met, and it was not being given the importance that this court found. A cardiologist appointment for a child of this age is extremely important. And heaven and earth should have been moved, and Mr. Fenton moved heaven and earth to come and get the child. Her response, as Ms. Hendrickson pointed out, is instructive. Her response was when he said, like I said, I'm on my way. You understand, I'm the one that gave child support your name and cooperated and wish I never did, because you're going too far with my child and you don't know. Plus, my child you don't know. Plus, you lied saying you'd never try to take him. And look, I never got notice of a damn court date, and you think you're keeping my child? Question mark. I find her guilty of willful and deliberate contempt in regard to the denial of return of that child on that occasion, failure to comply with the court's order. And anyway, I'm of the opinion that that again represents an intentional and willful deliberate violation of the court order or failure to bring the child back. And for that reason, I find her as well, in that instance, 2 counts of failure to comply with the court order, and found that she is in willful deliberate contempt, sentence her in each of those cases to 10 days in the county jail. I will suspend that based on the fact that it is her first occasion to have violated the court's order. But I want to make it clear one thing, and that is that I will not hesitate to lift that suspension and have you serve those 20 days in jail consecutively, which I'm allowed to do under an order for violation of a domestic relations order. I can make that 10 days in each of those counts consecutive to one another. And I will do that if you try to play games with this court's orders, or if you do anything that indicates to me that you are violating a court order. Your attitude towards Mr. Fenton is going to be reflected in your child if you are not careful.
And the judge lands it, guilty of willful, deliberate contempt on 2 counts for not returning Ashton. 10 days each, 20 total. Suspended only because it's her first strike, but he warns he can stack them consecutive if she plays games again. That warning is the sentence. Like, share, and subscribe.